Can you guys hear me now? Because I don't know what's working otherwise. Still muted? Then, what the fuck? Okay. Guys, sorry about that. I don't know what the hell's wrong with this damn thing, sometimes StreamYard. Anyway, welcome to the last Thursday of the year. Hold on one second. Okay, I guess it's working now finally. So, okay. What is the Verizon commercial? 1995? Yeah, thank you. All right. Welcome to the final Thursday of this year. If you guys are new, I'm Sean, no potentially criminal, and this is the Thursday stream, and I don't know why StreamYard fucked with my audio, but it did, and I guess it finally fixed. So, hello everybody, and yeah, I want to say hello to everybody out there on Rumble, Kick, Twitch, I'm still not banned from, Twitter, Facebook, YouTube, and then everybody on Locals. And Locals is basically a non-retarded version of Patreon. There aren't really any rules. And from there, we like to have fun. We have a live chat going right now. It's over at potentiallycriminal.locals.com. And then we have basically a page where you can post things that are going on, articles that are going on. In addition to that, we do 2 live shows every Monday night starting at 8:30. Sometimes we go for a full 3 hours. Sometimes we go for a little bit less. And then after this show, every Thursday night, we have an after show where we get to hang out and talk. So that's over at potentiallycriminal.locals.com. You can join for free. It doesn't cost you anything. But if you'd like to participate in everything, you have to become a supporter. That's $3 a month. And if you want to give it a shot, 1 month free, you can use the promo code criminal. There's no obligation. And yeah, that's at potentiallycriminal.locals.com. Kind of need to get to, wow, that was a whole lot of muting there. So, yes, this is some next level silent film shit. Thank you. So, all right. Well, let's get to who got first tonight. Over here on YouTube, the amateur iconic class got first. The timeless selection of first. Over on Tuggin' Me Tubin, he says, as the first one, says, Sean, please make a video on the Texas semi-truck driver standoff that happened yesterday. I have no idea what that's about, so I'll have to look into it. And then over on Locals, we have from Winter Soldier, Late. And it's funny because he said that before 9:30, so it's very pathetic of him. Also, if you guys are new, we generally try to hang out for a couple minutes, let people filter in, because, well, YouTube and the other services are not the best at notifying people for some reason. I'm not really sure. Let's see here. Where was Mike L saying, if I got you a conductor outfit, would you wear it on a stream? No. No. In a bit of sad news, and this is really just information so you're aware. If you happen to like your Glocks, well, the Glock father himself, that Austrian mad lad, not Hitler, but Gaston Glock, or Gaston. I'm not sure actually technically, because was he from like the more French side of things? I'm not really sure. Anyway, Gaston Glock passed away on Wednesday. He was 94. If you guys weren't aware, this is the man who developed the Glock. The Glock 17 handgun, which spurned the revolution of striker-fired polymer frame pistols that are pretty much unstoppable. So without Gaston Glock, we would never have had automatic switches sold on Wish for $5. And, yes, he died with his firearms empire and also his horse breeding empire. So yes, he has an empire of horse semen as well, breeding some of the finest horses around with his wife. So, but yes, and actually, I think CNN does actually a pretty decent job on this here. They talk about it. It's universal in mainstream use in America. The Glock handgun is ubiquitous in America. Over 65% of U.S. state and federal agencies use it, including many in the military as well now. And yes, this is the interesting part about it. He's an engineer and he founded the company and he made all kinds of stuff. He made all kinds of things until the late 70s when he decided to join the Austrian military's competition for a new handgun. He didn't have a whole lot of experience in that. He made knives, cutlery, all kinds of junk. Never a gun. And this was it. So it was very, very good. And yeah, the rest has been history. So rest in peace, Gaston. There's people out there in this world. There was a mourning of him that was found on Twitter. And I think it's actually really important to see how people have celebrated the man's life. It's all over the world. There have been funeral marches and celebrations of his life. As you can see, everybody's bringing out their Glocks and wanting to show everybody, I have a Glock too. Thank you, Gaston. You're helping me exercise my rights.
Ooh, young nigga. Dumb pistol, man. Big draws and shit. 30s and shit, man. So, man, how you boy rocket, man? How you boy rocket, man? Real shit, gang in the day, young nigga.
So, it's just great to see the entire world get together and celebrate what Gaston did for us. It's truly a beautiful time in this world. So, Unhung, we got a couple super chats as well, though. Unhung Hero for $2 says, I'm going to come. Don't come. Don't come. Zaven says, late and sober for January. Yes, all the muted here. Yeah, don't listen to the chat. I sound fine. Oh. JXC says muted and he didn't even know. That's very true. But you almost have to be, otherwise it really doesn't count as muted. Then it's me screwing with you. Because if I knew about it and I did it anyway, that would make me kind of like a sadist. Torturing you guys. Harvard Warble says, here's the problem. I wasn't even looking at chat, so that wasn't the issue. I had it scrolled up to the first one to show who got first. That was the issue. So that was my problem. I wasn't even looking. I have it all set up for chat. I just wasn't paying attention to chat. So, POV walks with roving Cyclops says, oh, thank the Lord, yes. RP for $5. Thank you, RP. It's saying, Turtle Boy's in jail. Why aren't you driving to Massachusetts to defend journalism? Is what he's doing journalism? Also, you're muted, you boomer. Like I said, is Turtle Boy doing journalism? That becomes the issue. And also if he's, I know what I know about Turtle Boy from what he did and my experiences running into him and seeing how he did stuff when he was a Chili DeCastro. So I don't find him to be a very credible human being. So that's why I'm not getting involved with Turtle Boy. Just saying. That's why. So let's see. Vodka says, no, stop, you're good. Okay, yes. Oh. Jeez, I'm trying to catch up here. Mystery Sniper says, today is such a sad day. It is my 21st anniversary. and I am not proud, but at least the marriage can legally drink now. Well, congratulations on your 21st anniversary to 21 more. Hope you've been enjoying it. If not, well, never too late to change, I guess. But I hope for you it is truly, to 21 more. A Glock brand horse semen, yes, there really is. There really is Glock brand horse semen. I think it's even on their website. I don't think it's on here anymore, but there was, for a while they had it set up for the Glock horse stuff for just a brief second. I guess it's not there anymore. So, Chaucer Fraud says, Glock had experience in metal manufacturing. That is experience. Yes, it is, but it's, metalworking. But making knives and curtain rods is not the same as making a handgun. Yes, there is metalworking involved, but that's about where it ends. Samuel Williams, the founding father, for $4.99. Thank you. The super chat is saying, I'll 3D print you a Switch for free. I mean, my neighbor will. Well, oh crap! The light went out on the lamp. But anyway, I don't need your help with the 3D printer because I've got one. Thank you to the lovely future Mrs. Martin 2.0. I got that, so I'm all set on the 3D printer. Thank you. William says, wow, Austrian is such a beautiful language. Well, remember, they speak German in Austria. The fish says, not watching the Browns game. If I watch them, they lose. So, no, I'm not watching. Besides the Jets, they'll be fine. All right, guys, we've been on for about, 10 minutes at least. I've been talking for 10 minutes that you can hear me. So, we're going to get started. And we will, I guess, get started with the serious stuff. And I don't know other way to get around it. But we have, first of all, we're going to cover the election, or the Supreme Court cert petition filed in the Colorado case for former President Trump. So as you see here, Supreme Court of the United States, bam. And it's on petition for writ of certiorari, and that means to be heard, to the Supreme Court of Colorado. So, and this is the petition. And the writ is what the court grants you. So they're not filing a writ. They're petitioning to get the writ. But you guys recognize some of the names here. These are people involved. And then you see the American Center for Law and Justice is here, the ACLJ, which is kind of like the conservative version of the ACLU. But all these people here are working together on this brief. There's a couple questions presented, and this is how a brief to the Supreme Court, you're trying to frame and have the Supreme Court address certain issues. And these are the issues they want answered. And then obviously they explain what they think is the right answer to them. But question number one is, whether the president falls within the list of officials subject to disqualification under Section 3. Whether Section 3 of the 14th Amendment is self-executing. And then the final one is whether the denial to a political party of its ability to choose a candidate of its choice violates that party's First Amendment right of association. I understand this is going on here, but really it's these two. These two are the ones that matter. This one kind of I mean, it kind of matters. But it doesn't really. I mean, that's an important issue, but this is really going to determine the tide here. So they talk about here the Colorado Republican State Party was the intervener, the appellee in the state courts. They talk about the other parties involved. They talk about how Trump was the intervener, appellee / cross appellant in the state courts and is a nominal respondent here. They talk about the proceedings that happened. This was the Colorado Supreme Court case, Anderson v. Griswold. This was the district court case. This is the one that Joe covered back in November. And then this was the hearing where the trial court denied the motion to dismiss. This is to allow the court to know what's going on. And they say, we're not aware of any other related proceedings under the Supreme Court rules. And you put this all together so the Supreme Court can take a look, because they might want to know what's going on somewhere. And, we have a we have a Rumble rant over on Rumble from Billdozer74 for $2 saying, why were so many commentators crowing about Trump being on the Colorado ballot? Did they seriously avoid reading the decision from those twat waffles? Pretty much. You could see on Twitter, like, oh my God, Trump got back on the ballot. He was already allowed to be on the ballot. The Colorado Supreme Court stayed their opinion if Trump filed for certiorari with the Supreme Court. They said the moment he does that, everything's put on pause and he stays on the ballot till the Supreme Court of the United States says otherwise. So yes, this isn't a big victory. This is literally something that had already happened last week. So anybody who's like, oh my God, it's such a big deal. It's not, though. It's not a big deal. Not at all. Not at all. So don't, yeah. A lot of dumb people out there. So table of contents. This is pretty normal for appellate things here. We're going to skip through all this. The appendix includes the opinion from the Colorado Supreme Court, the rulings from the judge, and then her final ruling in the trial court. We're not going to look through those. This is just so the court has it. They can reference it and read it because you have to provide it to them. Table of authorities. This is all the cases that are cited. Also includes any statutes cited or any other laws or sources cited. You can see here, this is all court cases, but then there's statutes. And then they also bring up state statutes. They talk about other authorities, including any sort of treatises, proceedings, anything that's out there. And then that also includes things like the U.S. Constitution. And then they talk about rules, Supreme Court rules. Or if you had rules of evidence, rules of criminal procedure, civil procedure, whatever it may be, those are the rules you might cite as well. So the opinions below, so the jurisdiction, the Colorado Supreme Court issued its judgment, and this court has jurisdiction under 28 U.S.C. 1257. Okay. They're just saying you have the right to hear this, you have the ability to hear this. They have constitutional provisions, but let's get to the actual things. We're not worried about statement of the case. We already know what happened. Let's get to the reasons for granting the writ. They talk about the first time in American history a former president has just been disqualified from the ballot. It's an unprecedented decision. It's rejecting a long history of precedent that individual litigants, state courts, and state election officials in each of the 50 states, plus the District of Columbia, now possess the legal authority to enforce Section 3 of the 14th Amendment to remove presidential candidates. And that's true now. That is what we're looking at, and this has now since kicked off a tidal wave of shit that is now rolling downhill. And they point out, well, 51 different ideas is great. This is a horrible disaster when determining whether or not a person's qualified to be president of the United States. So, the historical significance of this decision from Colorado cannot be overstated. And it's truly, this is a big freaking deal. A Supreme Court's removed the leading candidate from a primary and general election ballot. And that could change the course of democracy. Congratulations, you destroyed democracy to save democracy, Colorado. And its significance is not merely political, but legal. Rejecting a long history of precedent, they've now concluded that everybody can do what they want to enforce it. And they point out that this has already happened in other places. There have been other cases attempting to deny Trump to get on the ballot in 2024. In the District of Alaska, in a federal court, it was filed. That guy who was there, Castro v. Dahlstrom, he's now in the Ninth Circuit. and it just got filed, so it's getting dealt with. There's a case in the District of Arizona pending an appeal after the case was dismissed, so it's going to go to the Ninth Circuit. There's a case in the Central District of California. It got dismissed, though. There's one that was filed in June, and it was dismissed for lack of standing and rightness. There was another one in the Southern District of Florida, dismissed for lack of subject matter jurisdiction. There was one in Michigan. We're going to get to that because this one's actually kind of important. The Minnesota Supreme Court dismissed it. No errors. The issue of rightness. The Southern District of West Virginia. Summary judgment was granted saying there's a lack of standing. I mean, there's all kinds of things going on here. They go on further to state the district court rightly concluded Trump had the right and must be given access to the ballot. Any doubts regarding these interpretive questions should be resolved in favor of the democratic process. And that's what should happen. Well, what's going to happen? I don't know. But it should be up to the people to decide. It shouldn't be up to the courts. When you're not sure, you err on the side of allowing democracy to do its thing. If people want them, fine. If they don't want them, that's fine. And then they point out, should this court have any interpretive doubt, it should resolve that doubt in favor of the democratic process. And they're just saying, if you guys, when there's doubt, there's no doubt. When you're not sure, that means you can't. You can't make that decision. Now, the arguments they bring up here, the first one is that the president's not an officer covered within the disqualification provision of Section 3. I've said before, I didn't think this was like the best ever. They kind of did a better job on it now. They've had, I think, letting the Colorado Supreme Court smack them down a little bit made their argument a little stronger. They do point out the trial court reached the correct conclusion. Trump is not covered by Section 3. They point out Trump was never a congressman, state legislator, state officer. Section 3 only applies to him if he was an officer of the United States. They point out that, for example, and this is them doing their homework and going after the Colorado opinion, there's only a couple of times where it's clear that the president's not an officer, but they're very clear parts. For example, in the commissions clause, the president shall commission all officers of the United States. So when you are in the military and you are commissioned, your commission is through the president. Your commission signed by the president. So there's people who have, their commission signed by, Jimmy Carter, Ronald Reagan, George H.W. Bush, Bill Clinton, George W. Bush, Barack Obama, Donald Trump, and now Joe Biden. So that is how the commissions clause. Obviously, he can't commission himself, and they point that out. If the president is an officer of the United States, then he commissions himself, which doesn't make any sense. He's not among those specific roles, and he's not an officer. People don't vote for officers of the United States. Instead, they look to the president to guide the assistants or deputies subject to a superintendent's. They point out the presidency you can consider it an office. And yeah, it doesn't disqualify officers in a general sense. It only disqualifies officers of the United States. This is a term of art only used in 3 places. Section 3 of the 14th Amendment, the Commissions Clause, which we just covered, and the Appointments Clause. And the Appointments Clause, the president shall nominate by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States. Accordingly, it's the president who appoints the officers of the United States and has authority to commission them. He is not himself, therefore, an officer of the United States, which I think is a fair argument. They point out that, and this is, I think, a very good point here they bring up, that Colorado's Supreme Court's argument was that he was an officer in a general sense. But that's clearly not what was meant by these other clauses. The Constitution uses a distinct specific term, officer of the United States. And a generic reference in general parlance doesn't override a specific meaning if there's language in the documents you're looking at. The historical evidence is the contrary. And this is really good. They bring this up here. They talk about less than a decade after ratification of the 14th Amendment, Senator Newton Booth posited, the president is not an officer of the United States. Another senator said that according to the Constitution, as well upon the judgment of eminent commentators, the president and vice president are not civil officers. Okay. Now we're getting somewhere. And then they point out that, and this is where I love this, because the Supreme Court of Colorado likes to talk about we have scholars that are doing insurrection. They're insurrection scholars and, Section 3 scholars now. Well, there was a treatise at the same time from back then in 1878 that said the president is not an officer of the United States. So, yes, there were people doing research back then. I mean, if we're gonna defer to these guys, let's defer to them. And also at the time, Attorney General Henry Stansbury said, officer means the military as well as civil officers in the United States who has taken the prescribed oath. I think those are the powerful arguments. Those are really good. And getting back to this whole issue of the president doesn't take the official oath that was viewed as positive and thus not subject to Article 3, I don't think that's the best argument. I think all this stuff up here is the great argument that he's not an officer. They point out all executive officers take an oath to support the Constitution, but the president does not take such an oath. His oath is an entirely separate provision of the Constitution, Article 2, Section 1. And that he instead, and singularly, he's the only one that takes this oath, takes an oath to preserve, protect, and defend the Constitution of the United States. And that's true. This is distinct and different from the Article 4, Section 3. Article 5, Section 3. I still don't think this is the best. They point out that the 14th Amendment uses the words of Article 6, not Article 2. Yeah, I don't like these arguments. I don't think, I just don't, Brimstone says, I commission myself daily. Yeah, I don't know. I still don't think that's the best arguments to make, but I understand you got to make them. They point out that from 1889 that there's the simplest, most obvious interpretation of the Constitution in itself sensible is the most likely to be meant by the people in its adoption. And they point out that, well, the Supreme Court of Colorado didn't do that. The simplest and most obvious reading of Section 3 meant that it means what it says, disqualifying those who took an official oath to support the Constitution. Only the president they then make it actually a very good argument down here at the bottom. Only the president and vice president face nationwide electoral accountability. And if electoral majority of the voters decide they want him as a chief executive, regardless of their alleged or actual transgressions, that is their national choice under the Constitution. In short, the role is different in a way that matters. Now, I will just say for an aside, I know I mentioned this when I was on with Joe, the idea that, can the president commit insurrection? I think technically you can, because I brought the example of Charles I. He was accused of waging war on his people and the crimes against England, the people of England. I think you can, because at some point, if you are assailing the government and trying to unseat it, well, yeah, that is a rebellious act, an insurrection. I don't see how you could not do that. To argue you couldn't commit a crime, you're getting to, the idea of, well, is that a king? Because if I can't commit a crime and I could do what I want in that situation, I think we're kind of then chipping away at the foundations of popular sovereignty, which the Western world has held pretty dear for the past, 400 and some years. And going back to ancient Greece, but I mean popular sovereignty in the modern history. So they bring up, then this is the part I think that's actually probably going to get, this is where I think the real work's getting done. That Section 3 is not self-executing in the sense that it can't be used as an authority for state courts and litigants to use as a sword against candidates. And this becomes the issue, and this is one Joe brought up, that if it's increasing rights and protecting rights, it's automatic. If it's taking rights away, it requires enabling an enactment. And this is where Justice Samore from Colorado pointed out that the self-executing idea in Section 3 is a misstep. They point out that Congress and Congress alone can enforce Section 3. Yet Congress has not provided a private course of action under Section 3, and the only current enforcement mechanism is 18 U.S.C. 2383, where it talks about insurrection. And if you're convicted of the criminal offense of insurrection, your penalty is disqualification, among other things. And this is where his people did a great job. And they point out, after 3 years of investigation, first by the U.S. Attorney for the District of Columbia, then the special counsel, Jack Smith, nobody, the January 6th Commission, they haven't done anything with that. He's been indicted on several charges, but he's never been charged with violating 2383. That's pretty big. Pretty bigly. It's huge. The only time Trump faced an actual formal allegation of insurrection in the context was an impeachment proceeding, and he was acquitted. It cannot be rightfully said that the 14th Amendment, and they point out, going back to cases in 1879, that the 14th Amendment furnishes a universal and self-executing remedy for everything. And I think that's fair to say. It doesn't mean everything is automatically self-executing. They point out that the 14th Amendment provides a self-executing defense where it's protecting your rights. So the equal protection, that's automatically happening. But it's not meant to be, and they point out here, it's a self-executing sword. And as Justice Samore, and I forgot that he put this in there, he says that the rest of the justices said, I do not think self-executing means what my colleagues think it means. And yes, he did cite the Princess Bride, which you'll see that every once in a while. There was a famous, it's not famous, but there was a funny case in, I think, New York federal court where the one judge cited from Mo Money, Mo Problems. So it is something that does exist there. Jonathan Doiger says for 199 or Duger or Doiger. My apology if I messed that up. Says the O's are different for a reason. Listen, I agree. I just don't know if that's the most effective argument that you can make. So I don't think that's the best one. That doesn't mean it's not right. It's just, is that the strongest argument? It's a valid argument to make. This doesn't apply here. Do I think it's the best one? No. But I don't disagree that it's an argument that should be made. And then Slow-Mo Savage for 5 Canadian loonies, thank you, is saying, can you cover the two brothers that one shot the other and their prego sister in Florida? That's probably, that seems like a run-of-the-mill thing in Florida, so, No, I haven't heard about that one. I'm going to have to look into that one too. So I've not heard about that, but yes, that sounds interesting. If we can get to it tonight, I'll try. So, Jonathan says it's pronounced Duger. Okay, Duger. Nico says 5 loonies is like $2 real. Hey, they call them loonies and toonies, and the toonie coin is really cool. I remember having a bunch of those back in the day. They do point out that, and they also cite Griffin's case, and this is the one where Chief Justice Salmon Chase in 1869. I mean, this is as close as we can get to when everything happened, because this is back when the Supreme Court justices were riding circuit, and this is how they did it. He held that only Congress can provide the means of enforcing Section 3. It's not binding But there's nothing else that's binding. And that's when Joe covered his argument with Pisco, Pisco's like, well, it's not binding. There's nothing else that's binding. This is the closest thing to being on point, though. And that's important. If this is all you've got, there's only so much there. And yes, they point out, one of this court's most significant chief justices and an individual with the most closest in-time knowledge of the 14th Amendment. I mean, he was there when it happened. If we're worried about having the scholars talk about it, this guy was there, which I think is a fair argument to make. And they point out that the Chief Justice observed it's obviously impossible to disqualify with a simple declaration. It must be ascertained the particular individuals are embraced by the definition before any sentence of exclusion could be made to operate. And he concludes a due process clause foreclosed the argument that was automatic because without a trial. And we're talking about, nobody can be deprived of their life, liberty, or property without due process of law. Or to pass a bill of attainder or an ex post facto law. And at once, without trial, deprives a whole class of, persons of offices held for them. And that's important because you have an interest, you have a liberty interest in running for office. And I brought this up to Joe. There's an unenumerated right. Just like the right to privacy, if you want to argue the right to abortion, it goes to the right to privacy. But if it says in the United States Constitution, any natural born citizen over the age of 35 can run for president. Well, that means I have the right to do it because there's no other discussion about how you qualify. So I'm allowed to run. I'm 38. I could run right now. So I have a right in that. I have a liberty interest, I would argue. It's a liberty interest. It's a First Amendment interest. It's a political speech interest. I'd argue running for office is speech. So yes, to deprive people, you need a lot to do that. And Chief Justice Chase continued, now the necessity of this is recognized by the amendment itself in its fifth and final section, which declares Congress shall have the power to enforce by appropriate legislation. And I think that's important, saying Congress shall do something. It must do something. Generally, when somebody shall do something, it's generally only your responsibility. If it's may, there's going to be other parties involved that have the right to do something. But generally, when it's a shall, those are the only parties expected to do something. That's an argument I would have made. And they point out that, this Griffin's case has been used in other courts. In Maricopa County, it was used in 2022, that the plaintiffs had no private right of action to assert claims under the disqualification clause. This has been addressed at some points. And Justice Moore in his dissent pointed out that implementing legislation is also critical for due process. Without it, there can be no clarity as to what standards may be required. It doesn't spell out the procedures to determine whether someone's engaged in insurrection after taking the oath. It sheds no light on, do we need to have a jury? Can a bench trial work? What are the burdens of proof? What are the standards of review? So when you take it up on appeal, does the court review it de novo, or are they reviewing for abuse of discretion? What standard are they looking at? The application of discovery, do the evidentiary rules apply? Are civil or criminal proceedings contemplated? Can you do it as a civil action? Is it got to be only a criminal action? There's nothing here. And I think part of the issue is, if it hasn't, and this is where I brought it up to Joe, Congress hasn't done anything because they're idiots. They never, nobody thought this was going to be an issue, though, in fairness to them. And if there's nothing there, then you can't just make it up as you go. And they point out that after Griffin, Congress enacted the Enforcement Act of 1870 for the purpose of enforcing Section 3. And it allowed the federal government to go after people who were doing this. If you ended up running for office and you weren't allowed to, under the Enforcement Act, they could take you out of office. But the Enforcement Act was removed. Why? Well, by 1940, those guys were dead. So you're not just enforcing against the, Confederates. You now need the actual federal statute for insurrection. So that's where we get to it. And if there's any current descendant of the Enforcement Act, it is 18 U.S.C. 2383. And he's never been convicted of it, and he's never been charged under that statute. And they point out state courts lack the authority to rule him disqualified. You know, they have some more. He keeps going here. You know, this court previously explained that all states generally retain broad authority. The authority does not extend to setting new qualifications. And despite its lengthy arguments, the decision below is basic. The court feared the absurd results that would follow from not reaching the conclusion it was self-executing. But they point out the true absurdity here. You know, congratulations, you played yourself. Is rejecting 150 years of precedent to disqualify a former president for the first time in our history, based on untested novel 14th Amendment theories, which I think is a fair argument here. You know, we brought in brand new scholars. It was all untested. And they point out to read Section 3 as giving states veto power would turn this thing upside down. Now, this part here, Colorado's idea about its right to political candidates, I'm sure, I don't know how the court's going to interpret that, but I don't think this is where they're going to hang their hat on. This is not going to be the hill where everything happens. This is, you guys can read this on your own, but I think it's a very good argument, but that's not where it's going to happen. That's not where it's going to happen. And I don't know ultimately where we're going to go. But that is where we kind of stand with what's going on in Colorado. Iman Razu says presidentially criminal. Sweet Tooth says Sean would be better use as a judge. Need more judges respectful of the Constitution. Yeah, thank you. I try. Garrett says I make a great press secretary. 9-1. I do about 5 minutes. Like, oh, what's your question? Okay, have a good one. J-Rock says Maine Secretary of State. Yes, we're going to get to that. That is next. That is next. That is very much next. Elegant News for 199 says incoming 2383 charges after the new year. Jack is going to fix that. Yeah, maybe. I could see that, but at that point, it's even the Supreme Court's going to say, look, you didn't do that till this got brought up, and if you brought this up, you're acknowledging that was a hole in the process. So I think that they're going to be stuck in that regard. Then it becomes an issue of, if the Supreme Court says he did not engage in insurrection, though, and this is where I think, and I brought this up before with Joe, and people were mad at me for saying they can determine whether or not the Supreme Court was right to determine the trial court was correct that Trump had engaged in insurrection. They could say, no, that doesn't count. And guess what? If they're saying, no, he didn't engage in insurrection, if Jack Smith tries to do this, guess what the Supreme Court's going to say? No, he didn't engage in insurrection. So if he is, he's going to have to wait for that decision to come out, because that'll tell him, now, ideally, they may just do it on the first issue, but Supreme Court generally only does the most important issue they can get away with doing, and the other ones that'll say, sorry, we're not ruling on. Sometimes they lay it all out, and I have a feeling they're going to lay this one all out just to nip some shit in the bud, because things are starting to spiral. But yes, thank you for that. I appreciate it, and yeah, that's what I've thought as well, as possibly. Ethan says, Happy New Year's, everyone. Fuck the government. Yes. Yes. Kibbo says, remember to like and subscribe. Thank you. Yes. So, now, we got that done. Let's get to what happened in the beautiful state of Michigan. Because there have been happenings all over the country. So, the Michigan Supreme Court decided they're not going to hear a case. And they kept Trump on the ballot. They rejected the insurrectionist argument. So what happened in Michigan is people did the same thing. Oh my God, the Orange Man's an insurrectionist. Oh no. And the Supreme Court of Michigan said, are you sure about that? Because we're not sure. And the Supreme Court, this is from the 22nd or 27th, so yesterday, they declined to hear a case arguing that Trump should be excluded from the ballot. They're just like, yeah, he's going to remain listed. Now, I don't know if that means ultimately there might be challenges later again for the general election. I think that's a real possibility here. This is not it. Just like Wangro says in Heat, he ain't gonna forget about you. They're not gonna forget about this. They are going to strike again at some point. So they are not getting involved. And the Michigan Supreme Court said that it's not persuaded by the present questions. They refused to consider a mid-December decision by the Court of Appeals, and that neither the courts nor Secretary of State Jocelyn Benson can bar Trump for being a candidate in the Republican primary. And it's interesting that in Michigan, which, given their governor and all the other communist scumbags running around, said that, this is put forward by a political party and they have an obligation to ensure that proposed primary candidates are eligible. Okay, well, they point out, though, what's the difference here? Well, the difference comes down to the laws of the state, okay? So we will see. They point out that Colorado state law allows a duty to exclude disqualified candidates. They point out Michigan, through anything including a primary, Michigan doesn't allow it. So in Michigan, he's probably going to be allowed to go to the primary, and then somebody's going to challenge him for the general. And we'll see what happens. But hopefully by that point, the Supreme Court's put this all to bed. But that's not the big one. Where the big one is Maine. And why is it Maine? Well, so in the state of Maine, the Secretary of State, there she is, Sheena Bellows. I mean, she looks like a Karen. I don't know what more you could say about her. She issued a massive decision where she goes after all of this. And it's very interesting because I didn't know about this happening until today. So on December 15th, she held a hearing. I never heard about this. I don't know how many people did. Show of hands if anybody heard about this, because I did not. So there were three challenges, and the first two challenged him under Section 3 of the 14th Amendment. The fourth one, filed by an attorney, challenges qualifications on the 22nd Amendment. Now, they point out that the Secretary of State determined that his consent candidate form was false because he's not qualified to hold office under Section 3. I'm surprised there isn't now also an action by her to charge him with filing a false form, providing false information under oath under Maine law, because communists going to do communist stuff. The procedural history here isn't that big a deal. They claim, he violated his oath, the insurrection, yada, 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 or is given aid and comfort to the enemies thereof, which is what South Dakota is doing to go after Biden, claiming he's allowing the border security to fall apart and he's giving aid and comfort to the enemies of the United States. The second challenge from an attorney, and that's the thing. Of course this guy's an attorney. Of course this guy right here is an attorney. And I apologize to people on behalf of attorneys everywhere. My bad. I'm sorry this guy is involved like this, but he argued because Trump had stated he won the 2020 election, he's barred from office under the 22nd Amendment because he's a two-term president. I mean, this is the most Reddit tier thing you could do. I'm sure this guy has NPR stickers all over his car. And that's a sad thing because, I bet he listens to Prairie. Well, he was probably very upset when Garrison Keillor got taken off Prairie Home Companion. And to be fair, I was too, because Prairie Home Companion was pretty good. If you guys never got a chance to listen to it, you missed out on a lot. And you'd be like, oh my God, Sean listened to public radio? Yeah, wasn't bad. I enjoyed it. But yes, this is just garbage. What this guy did here, on behalf of attorneys everywhere, I apologize. This is, well, we're douchebags, so yeah, this is what douchebags do. The third challenge said he's barred because he engaged in insurrection. Okay. On December 11th, she issued a notice to everybody that there was going to be a hearing on December 15th. Once again, I never heard about it. So, oh gosh. Now, it's funny because parties were exchanging witnesses. They received timely applications to intervene from the Citizens for Responsibility and Ethics in Washington. Crew. If you guys are thinking, I've heard that name before. Yeah, these are the people out of Colorado. They're not going to go away. They're going to be like roaches. You're never going to be able to get rid of them. They're going to show up everywhere. So, getting through all of this, she talks about what was presented, how things were done. She talks about how she allowed the parties to present evidence after the hearings. I'm not going to get into that because there's just a lot of it here. There's a lot of Maine like procedural administrative law things, which I'm not a Maine attorney. I can't comment on their administrative provisions, but that's not going to be the linchpin of the issues here. The findings of fact and conclusions of law. They talk about the issues that there were due process issues. And I think this is fair for Trump to make a due process issue. The one party that was had exhibits, they offered a Dropbox link, which didn't work. But they provided evidence during the hearing. And this is where Justice Sarmour goes on again and again. What type of standards are we having? Because he said civil or criminal. We're not even in civil or criminal. We're now dealing with the fact this is an administrative hearing. That this lady thinks, it's administrative, good enough. Good enough for government work. That and that's the thing, with an administrative hearing, there really aren't any rules. And I've been in administrative hearings before. The rules of evidence are fairly lax. You're dealing with people who generally are not attorneys or have a lot of legal training and experience. And actually, I don't know about Sheena Bellows. Does she have any? No, she doesn't have a legal education. She has a BA from Middlebury College. Where does she? Let's see here. What did she? Yeah, she got a BA for her thesis on economic and environmental sustainability. Oh, I'm sure that was a barn burner to learn about. I'm sure her writing was redder than this highlighter. Just a little bit. I am sure it was all red. Red with envy. They talk about the APA, which is the Administrative Procedures Act. Now, there's a federal APA, but many states included and basically copied their own. Saban says a BA in actual communism. Yes. Okay, Claude, yes. Not even a Maine attorney, not even a minor attorney. Saban says lax rules of evidence, bring that hearsay in. Yeah. That's the same thing, though, in Colorado. That was an administrative proceeding, even though there was a judge presiding over it. A lot of that stuff still came in anyway. So this is where it's just garbage in that regard. But, there's So she basically says a lot of stuff I can do whatever I wanted. She also pointed out there was ample notice because a majority of the evidence was already done in the Colorado cases. And Trump's attorney in this case in Maine, Scott Gessler, this bad boy right here, Scott Gessler, he was the guy involved in all of Trump's stuff in Colorado and the former Colorado Secretary of State. So their argument is, these have already been done somewhere else. That is a very shitty argument, though, in my opinion. Oh, well, it's already been done in another court. Okay. It's still a new court. You have to follow the rules of due process. But then she says, well, actually, it's not really even I can do what I want. It's my name, Sheena. They talk about there were some issues here that Trump had exhibits 26 through 51, but he never had identified like what were exhibits 1 through 25. There's some weird things that Trump's team did here I don't get. J-Man says, usually administrators aren't elected either. Well, here's the thing. You can be elected and proceed over an administrative thing. That's not necessarily but I get what you're saying. Yes, technically, usually in administrative, when people think of administrative hearings, you're in front of some bureaucrat. They get through all of this here. They ruled, and they point out that under the rules of evidence, government reports are, considered to be trustworthy. But she's like, it's all administrative. I can do what I want. I'm sure she laughs like Fran Drescher. And and they basically, and what happened here, and this is what I mentioned this. Once this happened in Colorado, people are literally just going to copy and paste everything that happened. Copy and paste everything that happened in Colorado and just run the same playbook. And that's what they did here. So, she determines that everything was corroborated. She determines that everything that was going on here, she makes her statements. And then look, and this is what happens. She's now citing Anderson. She's now citing from Anderson v. Griswold. She's citing the Trump case now. And state legislators can't create new provisions, but they can choose to establish a process to exclude candidates. And she goes on to argue why state law allows her to do this. And this is where I can't comment on it because I don't know about it. And that's really not the problem either. The Supreme Court wants to thump all of this, fine, and kill it administratively, great. But I don't know Maine law enough to know anything there. They immediately throw out the whole term limit thing because it's all about whether or not you've been elected president. Now, I like the actually been elected. That's almost like a dig at Trump. But she's pointing out, like, dude, come on now. Now, this part is interesting. She points out that otherwise, political grandstanding does not trigger the bar of the 22nd Amendment. So she acknowledges Trump engages in political grandstanding. But remember, the Colorado Supreme Court said if Trump says it, it's completely different than any other politician or person. GM says, I talked about Coach Red Pill yet? No. We'll get to him. Now, I tried reading through this. I ran out of time. So now we're reading it all anew together. Mr. Trump, he engaged in insurrection. He did the bad thing against the United States. And he's not qualified to hold his office anymore. Whoa, no. So there is no other mechanism which I am aware of, and this is her saying, and a Maine voter can challenge the qualifications of a candidate for office. It is the means by which I am authorized and duty-bound on the terms of the office to which I swore. Well, there is another mechanism by beating him. I would argue that's the ultimate mechanism. But let's get to the determinants here. This is the funny part here, because she does this. His concerns about the adequacy of the proceedings are without merit. He had the opportunity to present evidence, call witnesses, cross-examine, and argue at length both the legal and factual arguments germane to her decision. But as Justice Sarmour pointed out in Colorado, based on what? What's the setup? What are the standards? According to who? Is this your due process? This is her interpretation of it. This isn't Congress's interpretation of due process. And yes, while the timeline of the proceedings has been compressed, this is how the first time that Trump or his attorney Gessler has confronted the applicability of Section 3 of the 14th Amendment to a presidential candidate. That is not how you should argue. That is not a valid argument. Hey, you've already had your balls in a vice once, so what's a little more pressure? We'll give it a couple more cranks. No, that is not a valid argument. Hey, you've been hosed and put over the barrel, so well, we're just going to push a little more. We're going to put you back over the barrel. Well, you already done it. We've already kind of screwed with you once, so it's okay if we screw with you again. That's literally her argument here. Also, it's not the first time Trump has had to grapple with whether the evidence presented, which directly mirrors what was offered in Anderson, demonstrates that he engaged in insurrection. Okay, great. That was a separate time and a separate hearing in a separate place. Yeah. Aaron Hack says, I imagine that would hurt. Yes, it probably would. These are the arguments of these brilliant people. She says, well, I'm cognizant of the fact that my decision could be soon rendered a nullity by a decision of the U.S. Supreme Court. That possibility does not relieve me of my responsibility to act. Okay. Now, I think it's funny because she does say, she talks about him engaging in insurrection, but she hasn't talked about it yet. Where the fuck is she going to do it? Okay, well, I guess we'll get to it at some point. Section 3, self-executing. And it's funny because now we have a non-attorney. She has attorneys on her staff. Certainly she has staff attorneys and attorneys advising her. But this is a non-attorney making legal determinations. And as I said, guys, I love y'all out there. And I have nothing but love for the normies. But guys, just like when Joe was arguing with that guy, he's like, well, I looked up online. You can't WebMD this stuff. I found a law review article. No. No, you don't get to, you can do that. You can do that. But that's like me going up to a doctor, be like, hey, man, I checked this out on WebMD. Or going up to an engineer, like, hey, man, I bought this book called, Stress Fractures in Titanium. And I got some I want to input some engineering things to you. No. Doesn't work that way. Harbor Warple says Russell Greer legal tier advice. Yeah. Pretty much. Although she doesn't have to worry about her drooling all the time, so. You guys know Russell Greer, you get it. So, let's get back to this, though. They get to, as a threshold matter, Section 3 refers to holding office rather than running for office is not noteworthy. Yes, you're brilliant, the brilliant legal jurisprudence here. Section 2, Article 2, qualifications don't refer to running for office either, but are phrased in terms of eligibility to the office. Yeah, well, let's get to, she's talking, well, where do you talk about the, the Constitution repeatedly refers to the presidency as an office. Okay. Article 1, Section 3, Article 2, Sections 1 and 4. And constitutional amendments, the 12th Amendment, the 22nd Amendment, and the 25th Amendment. Noting the Constitution refers to the presidency in office 25 times. Yeah. Well, this is the history of Section 3 firmly supports the idea it covers the presidency. Yes, using the professor who just became the brand new insurrection scholar. He testified that members of Congress believed the presidency to constitute an office when debating the language of Section 3. Yet we literally have them all saying we're not 100% sure. And even the Chief Justice of the United States Supreme Court saying, yeah, it's not an office like the way you think it is. So, they point out that they go back to the arguments, the early drafts of Section 3 referred to the office of the president and the vice president. Then they were removed, and the language is not intended to be as expansive. But apparently the challengers in Maine claim that the early draft confirms the drafters both intended it to be covered by Section 3 and considered it in office. But they didn't include it, so how do you know that they did that? If it wasn't included, you have to assume they intentionally left it out, or are you just arguing they're morons? And the adopted language contains a much broader catch-all. I mean, does it really a broader catch-all? That was included in the draft. This makes good sense. Yes, be in your legal mind that you don't have. The president's oath doesn't change the calculus. Yeah, it's like I said, it's not the biggest thing here, but this is the issue here. I wanted to see this. Yes. Well, how is she claiming this is an insurrection? Okay, let's see here. Let's go. Let's get to the money shot here. The parties do not meaningfully dispute the events of January 6, 2021. Well, I don't know. Determining whether it's a riot or an insurrection is a meaningful dispute. People violently attacked the Capitol with the intent of preventing the certification. Okay. As described in the GAO report, the Government Accountability Office, and they do reports on everything, over the course of 7 hours, 2,000 people entered the U.S. Capitol building and threatened the safety of the Vice President and members of Congress. Oh, no. Oh, no. Oh, no. They had to put bags over their heads for their little gas masks. They looked so stupid. It was so funny. That was one of the best parts about this. That was one of the best parts. Our congressmen, they were forced to. I mean, this was great. This is great. Like, I forgot about how, it's just when they bring this up, it was so dangerous. It was so dangerous. It just makes you want to point out, like, cope, sieve, dilate. You're looking at it and you just want to look at it and you're like, I forgot how funny this was. I mean, look at these people. They're literally wearing, like, it's like what you cook your chicken in or your turkey in at Thanksgiving. You put it in the bag. Those are escape hoods. They were made to wear bags over their heads, plastic bags over their heads. You know what? That's the look of people. Oh shit! The boss is angry because considering they do work for the people. The people are angry. Yeah, they look like any employee. Because I've been that employee before. Oh God, the boss is angry. Well, that's how that goes, man. So, Iman says that's a suicide hood. Well, apparently it didn't work. Notice I didn't threaten anybody. It's just whether or not they committed suicide. So, I didn't do anything there. The attack resulted in assaults on 174 officers, including 114 Capitol Police and 60 D.C. Metropolitan Police Department officers. I thought police were, it's probably good, though, because they're a bunch of racists who arrest black people and are part of the prison industrial complex and the school-to-prison pipeline. So isn't it good that a bunch of racist police got beat up? I thought that's what we wanted. Guess not. So, in making their case, this constituted an erection, or constituted an insurrection. I'm sure they like erections, though. They rely heavily on the proceedings and evidence from the Anderson case. Yes, much of that evidence of that record evidence is in the record here, and I find the reasoning of the Colorado Supreme Court compelling. That's because you're a normie and you're an idiot. You're being lazy and just saying, "Oh, they said it, I'm good." Lawyers looked at it for me. Even without the benefit of the Anderson decision, I have little trouble concluding the events were an insurrection with the meaning of Section 3 of the 14th Amendment. The professor defined an insurrection as a public use of violence by a group of people to hinder or prevent the execution of the Constitution. That is still a very, very... All 2020 was an insurrection, then. They criticize the definition as too weak and disparate in time, but they offer no workable alternative definition. It's not their job. The burden's not on them. That said, though, Trump's claim was the insurrection, well, they offer a workable alternative definition. This seems to be one. Be violent enough, potent enough, long enough, and organized enough to be considered a significant step on the way to rebellion. That's a pretty workable definition. It's both ambiguous as a standard and poorly supported by the evidence he cites. An insurrection need not involve military-style weaponry. Going from the Central District of Pennsylvania in 1800. Military-grade weapons like guns and swords are not necessary to make such insurrection or rising amount of levying of war. Okay, but what does then? What does? So they're pointing out an insurrection doesn't even have to involve bloodshed? Okay. Or even be highly organized. Then you want a workable definition. You're worried about having a workable alternative definition. A workable alternative definition. And the definition you're relying on, though, says it doesn't have to involve weapons. It doesn't have to involve violence. Nobody has to get hurt. Yeah, people could get hurt, but it doesn't have to happen. It doesn't even have to be organized. How the hell is that a workable definition? It's just a use of violence by a group of people, okay. But if it's a use of violence by a group of people that doesn't involve bloodshed and doesn't involve weapons, how exactly are you being violent? Is it an insurrection of fists? Come on now. How is that a workable definition? But hey, you know what? As Weinbaz one told me, working without tools, and she's working in legal definitions, and she ain't. Yeah, Skip like he says we're insurrecting this chat just by posting. Yeah, you guys probably are insurrectioning like a boss. The police officers were assaulted. Yeah, those racist police officers were assaulted. Vandalized and stole property and ransacked offices. Oh no. That man putting his feet on Nancy Pelosi's desk, that was it was almost like the Statue of Liberty was sucker punched in the back of the head. Oh, it's just so sad. And they basically, she lets them reheat all the stuff from the Colorado hearings. All the garbage. It also cannot reasonably be assumed the rioters were organized behind a common purpose. That purpose is not evident only from the context discussed below, but from the very chants and recitations of the rioters themselves. But literally when they got into the building, there was no unity of what they were doing. Was stealing the lectern? Was the lectern guy, was he like, haha, if I steal the lectern, they can't do their things. Or some guy's like, if I steal the gavel, they can't gavel to order. I've defeated them. Once again, these are the problems, and I think, absolute garbage. John, this is the worst thing about the insurrectionists is they didn't win. I'll present that without comment. So, this violent disruption of Congress's duty, through a transparently public use of force, meets both Professor Maglioccia's historically accurate definition of insurrection, Mr. Trump's alternative definition. Therefore, I conclude that January 6th was the most significant breach of the Capitol in over 200 years. There have been, in 1954, some Puerto Rican dudes had pistols, and they stood on the balcony of the House chamber and stood there in the top of the House chamber on the balcony and started dropping people with pistol fire. They turned the floor of the house into a fucking shooting gallery. Like, dudes were getting it on. And this was the most dangerous thing. This was the most dangerous thing. The most significant breach of the Capitol in 200 years. I mean, does she even know that happened? I mean, I'll tell you this much. In Puerto Rico, they know what happened. They're proud of it. Which, I mean, it's kind of based. It's kind of based, really. You're like, you know, brave Puerto Rican lads put in some work. I mean, they live where few men dare to dream. Fair Frozen 55 says they had German pistols and they killed a bunch. Lolita Rabram was a woman who chastised two figs to start shooting. Yes. Cat Madison says the Weather Underground blew it up. Yes, they did. Which is funny because Barack Obama started his career in Bill Ayers' home. Bill Ayers, the head of the Weather Underground. They put a bomb in the Capitol building. So, yeah. There's a lot of things that have happened in the Capitol building that are dangerous. I mean, we had a senator beat another one almost into a coma before. Yes, Two Scoops said, does she not know about the war vets in 1932 occupying the Capitol with a giant encampment? Yeah, does she know about the bonus army? Fenris says, read my super chat. I'm going to get to it. I was just trying to get through this here. I'm working on it. Give me a second. I'm getting there. Just need to finish. You know what? Fine. We'll get to it now. Carrie. Okay. Carrie's saying, what would be my stripper name? My stripper name would be Malcolm Sex. That would be my stripper name. Patty says, insurrection-y, insurrection-y, insurrection-y. You can't be president when you're all insurrection-y. Patty also says, Sean, don't worry. No one thinks it's you that makes people hate lawyers. It's the lawyers. Well, that makes me feel better. It's not my fault. I'm just trying real hard, boss. It's like John Coffey. I'm just trying to take it back. Fair Frozen 55 for $2 says, yes, by this logic, we've had a female president as well, based on Trump's claim. Yes. And Jacob Castro says, that's unapproved history, Sean. That's what I do. That's what I do. Sporkio says, walk it over on Rumble. It says, Waukesha, Chaz, Chop, no problems. Yep. Kimbo Nice says you found a law review article. Nippa, please. Yeah. I'm serious. So that's when people are like, I found a law review article. Oh, you did? That's cute. That's cute. Fenris, WF. Or Fenry, single white female. I'm not sure which. I'm thinking it's more Fenris. Fenris, like Wolf of Fenris, but I'm not sure. Says, I need at least 3 more Heat references. Oh. I'll work on getting them in. We got time still. Oh. So, yeah, this is, and all she does is basically this is not inventive. Oh, well, what they did in Colorado is good enough. See, it's all what they did here. It's what he did in Colorado. I mean, this is pathetic. Because that's all they did. They literally just copied and pasted it. Oh well. Oh well. We'll see what happens from there. I got nothing else for you guys on that. This is just garbage. Garbage and a half. Now, getting on to probably some more funnier things. And I mean, here's the deal. Also, if you guys were wondering how this is going to break down the case with Trump and what's being done in his DC case Jack Smith is running, whether or not the Supreme Court's going to hear their appeal directly, or they're going to make him go to the DC Court of Appeals, the DC Circuit Court, and then go up to the Supreme Court. That one's getting decided first. The Supreme Court has already said that came to us first. We're going to rule on it first. So they're going to make the ruling on that, and then they're going to address this one, whether or not they're going to take it. I think they have to. I mean, they got to take it. But they're not going to do this one right away. We're going to have to wait. We're going to have to wait for the Trump case to get started, and then we'll deal with this one. So you guys are looking at a timeline. It's not going to be right away. So, I mean, and I think I mentioned this before, even when it came to things like the Nixon subpoenas for the White House tapes, it took them like 60 days to sort that out. And that was something where guys were facing trial and the clock was ticking. So this is probably going to be at least 60, 90 days out before we find anything out on it. And the primaries will be over, and we'll be dealing with general election challenges. So we'll see what happens there. Fernando says, how is this getting pushed so fast? They've got to. Augustus Tiberius says, Sean, let's be honest, all these people know how to do is plagiarize. Yeah. And Offender saying, do the trifecta. You watch Heat, then Tombstone, and finish it off with Red Dawn. Yeah, that's not a bad order. I think Heat's always a good one to end on, though. Pepsi Man says, PSA, Heat is free to watch on YouTube with ads. I didn't know that. That's good. So, J-Rock says, disagree. The Supreme Court will take it up on an emergency basis. I don't disagree. They'll take it up, but I think the timeline is still going to be. They took up the Nixon stuff on a pretty quick basis, and it still took them a while. So we'll see. But I appreciate it, J-Rock. Yeah, and you know what? If you're right, I don't think we'll hear anything before March. That's the big thing. I think the primaries are going to happen. So that'll be interesting. Tuggin Me Tubin says it's amusing, over on Rumble says it's amusing they still gloss over the May 29th insurrection, where they literally set a guardhouse and church on fire. Yep, they do. But hey, and it was the guardhouse at the White House, so. But that's not an insurrection. That was not an assault on democracy. Okay, now moving on to, well, if you are a follower of Kiwi Farm, some sector news. And from the sector, we have the saga of Gonzalo Lira. If you guys aren't familiar with Gonzalo Lira, he's also known as Coach Red Pill. And he was like a dating coach and how to be a man's man, manly man, and he did it from Ukraine. Now, Gonzalo Lira is an American citizen. He's a natural-born American citizen and lived in Ukraine and talks shit about the Ukrainian government on a consistent basis. Now, what happened to him? Well, the Ukrainian government, which, let's be real, isn't the best to deal with, charged him with multiple crimes. He's been in and out of jail, dealing with things here, and, he had a case that was pending where he had, how is it the best way to phrase this? Basically, he had said things that were contrary to the narrative the Ukrainian government was pushing. Apparently, that's a crime. I mean, nothing like a true European democracy to have a law like that on the books. I mean, that is who I want to give my tax money to. So they charge him, and he was facing access, so he's Ukraine's Viva. Well, no. He's far more, let's say Viva. I don't know if you guys have seen when he was posting it. He's jacked. Dude's yoked. I couldn't believe it. But no, Viva is actually somebody I'd like to, Viva's cool. Coach Red Pill, he's just Coach Red Pill. Gonzalo's just cringe. But he's also, if you guys go on Kiwi Farms, he's got a page. It's, a lot of his things have been documented and archived. He's just not the brightest guy in the world. And the Ukrainians charged him with multiple crimes, offenses to the motherland, all kinds of nonsense. So, what happened here? Well, there have been his stuff has been pending. Now, yes, this is all in gobbledygook Cyrillic, so I don't understand it. This is Google translating it. He had a very limited non-public trial that basically he had done things they didn't like. And at a court hearing, the prosecutor wanted to extend things 60 days because he's sick. But at the time, he basically got sentenced to 13 years in prison here. This is rough to read, and it's mainly because it's Google Translate. It's just awful. But he got a 13-year prison sentence out of all of this. So, yeah. And I read through this earlier. Oh my God, it is painful to read. It is painful to read. So, he is doing prison time in Ukraine, which I think is interesting. The U.S. government has not actively fought to get him out, but, that's part of the issue here. If you are screwing around in foreign countries, you get what you get at times. And the U.S. government doesn't like you. They're not going to back you up at all. So 13 years in Ukrainian prison in the middle of a war, I'm sure that's not going to go poorly at all. Pepsi Man says he's doing time. Coach Red Pill's doing time in Ukrainian prison for the crime of having Chilean citizenship. Yes, he was a dual Chilean citizen as well. No, I didn't think this is any proof of life. Not that I'm aware of. You guys were aware also the Trun of Kiev that we like to mock was involved in testifying against him, which, I'm sure that's well that an American was helping another American violate their civil rights, but, in an official role as a governmental agent, but what do I know? Amateur iconoclast is one of the Ukrainians sent him to the front line. Yeah, I don't know. Oh. Cynthia says, am I planning on having kids? Way too much time in Kiwi Farms. At least I don't have so much time I make like 55 sock accounts, Cynthia. So you have fun with that, sweetheart. Chris says he's only going to do 3 months in Ukrainian prison, and after that it'll be a Russian prison. That would be hilarious. The Russians take his prison and release him. Oh. The Suyar says Coach Red Pill is clearing minds at the front. No, they use their own troops for that. They use Ukrainians for that purpose. They use the Ukrainians who only speak Russian for that purpose there. So that is, yeah. So that's kind of the update there. If you guys were wondering, I just thought that was, we did it again, Sector. You guys did it again. And other news, and I only learned about this case very recently. You guys are unaware, Gypsy Rose Blanchard was released from prison 8 years after was involved in killing her mom, who had been abusing her with Munchausen by proxy. If you guys were not aware, Gypsy Rose, and this is her, she was sentenced to prison, and her mom basically throughout her entire life and growing up had engaged in Munchausen by proxy. This girl thought she had cancer, her hair was kept short, and her mom had kept her sick. Now, certainly this Gypsy Rose had mental health issues. Probably some cognitive issues, too. Well, she got her boyfriend and they hatched a plan to kill her mom. And they killed her. And from what I've read about what her mom did, her mom was a big scam artist. So, for the mom, Dee Blanchard, I hope it hurt like hell based on what she did to this woman and to her daughter. But they point out like they made her stay in a wheelchair. Pumped her full of drugs and convinced the world she suffered from leukemia. Well, she finally got the ability to have her boyfriend help her kill her mom. Erin says her boyfriend was not all there. Yeah. Neither of them were, but at some point he knew that you can't just go kill people. And I think that's part of the reason why he got more time than she did. They're willing to cut her some slack because she had to deal with her mom. So she was sentenced to 10 years in prison, but was granted early parole. So she gets out. And, this is Dee Dee with Gypsy Rose. And yes, I understand Dee Dee looks like a man wearing a wig, but whatever. So that was interesting news. Stacy says the mom had it coming. Yeah. Stabby says rest in piss. You won't be missed. Yeah. Based on the way this woman treated her daughter, I don't think the world's that worse off that she's not around anymore. Okay. In other news, and we covered this last week, Ruby Frankie entered her plea of guilty with she's the 8 Passengers mom from the YouTube channel, and she entered a guilty plea to 4 counts of child abuse, abusing her 2 children. Well, her partner in this, and I'm sure there was a lot more partnering going on, Jodi Hildebrant, also entered pleas of guilty to the exact same thing. And this happened just yesterday. She did it to 4 counts of felony child abuse. So she's looking at 1 to 15 years on each count as well. So this will be very, very interesting because remember Ruby Frankie's plea offers were involved that she had to testify against Jodi, and then it was just the idea of we're not going to oppose your parole. So now that Jodi has pled guilty, I'm not sure how this is, she doesn't have to testify now. So it'll be very interesting to see how the judge handles this. They're both going to be sentenced on February 20th. And I think it was very interesting. And Jodi Hildebrant was the founder of an emotional healing company, Connections Classroom, which purported to help people deal with addiction and mental health issues. I'm not sure how making these kids and beating them for drinking water out in the desert sun was an emotional healing, but what do I know? I'm not a professional. Apparently she wanted to plead guilty because she didn't know what the children had to testify. She takes responsibility. Well, Burberry is saying, sorry, going back to the Gypsy Rose thing, she convinced doctors to remove her salivary glands. Holy shit. Ooh. That is awful. I hope it's hot where Dee Dee lives because that's awful. I didn't know that. That is disgusting. So, this VR says Danny uncovered this. Yeah, I think I learned it when I was on Danny's show the one time. J-Bet says, are you going to read the details of the abuse? We did last week, yes, making them sit outside in the hot desert sun, hauling rocks and things around to the point where they were getting dehydrated. If they tried to hydrate themselves, they were beaten. That they were handcuffed if they tried to run away. That they were given crappy food compared to everybody else. Oh, yeah. What Ruby and Jodi did is horrible, and I'm sure Ruby is going to go to prison for a long time. She's not going to be able to say, I didn't know it was bad. I got wrapped up in it. I got a little carried away. No, using the belt a little hard is getting carried away. Trying to treat your kid like it's a labor camp, it's not going to be, I got carried away. Carrie says Ruby and Jodi was fuck. I bet they were. So it's very Jeremiah Maddox says they were healed from having emotions. Yes, that's exactly it. That's silver linings right there. That's how you got to look at it. Jonathan says the food thing kills me. And Kat says, where was their dad during this? I don't know. I'm not sure. JC Adult says it sounds like the movie Holes. Yes. Which that's also that movie sucks because the crappy luck for the person. So, but yes, both will be sentenced February 20th. So it will be very, very interesting. So they point out the details of Hildebrandt's abuse mirrored those in Ruby Frankie's statement, including the forced physical labor, the withholding of food and water, denying entertainment, including books or anything, and enforcing Ruby Frankie's son remaining outside all the time. When he tried to run away, his feet were bound, he was tied to weights, and he was given homeopathic remedies for the injuries. Well, that's because they didn't want to go to the hospital. Hildebrandt in the statement agreed that they tried to convince the boy he was evil, and the punishments were necessary to repent. You make me beat you. You make me want to starve you and give you water. J-Rock says, I worked outside with shoes in the deep south summers when I was young. Yeah, but I'm sure it wasn't like this, where if you got a drink of water, they didn't beat you for doing it. I think it was a little different there. Yes, Horrible Warble says, look what you made me do. So, yeah, it will be, and also just like Ruby, she's agreeing to consecutive prison sentences. So yeah, it's going to be very interesting to see how long they go. Well, J-Rex says I wasn't beaten. You're correct. I'm sure you're allowed to get water as well. I think that's certainly a big difference there, and I'm sure you believe it or not, my Skinnery days, working outside in the hot sun, sloughing concrete around and asphalting was not fun. But if nobody ever beat me for trying to drink water. J-Rex says, I got to drink water from the hose. That's the best. That's the best. It's the best kind of water is hose water. Charlie says, YouTube's taken away my likes on this show. Hey, they fear me. They fear the power that I possess. Well, not the power of a Jedi, though. God, that was I'm sorry, guys, that was cringe. That was cringe. That was awful. I'm so sorry. That was horrible. I should get punched in the face for that. That was horrible. Okay. Now getting back to the Scott X says lick the bottle as penance. Not gonna do that, no. You must say 14 Baldos and all will be forgiven. Yeah, I'm sure it will. Bring Clyde on and it will be forgiven. Oh, hold on, I'll grab him in a second. Let's see here. Where is the next thing here I wanted to get to? This was very interesting because I've seen this, and when I first heard about it, I don't think I've done this one yet. I wanted to, but I didn't. We didn't get this far. Because now it's... Did we do this yet, guys? About the kid who got in trouble for taking a leak? I forget. I need your help here, chat. Inner City Pigeon says, I prefer gutter water. Jeez. Yeah. No, I drink ditch water. And that's how hard I am. So we have not. Good. All right. Why did I get rid of that? Why did I drop out here? So this is down in Alabama, and a woman and some people were dealing around an attorney's office, taking care of some things, and they had their kids with them. That's not uncommon, and there wasn't a bathroom they could use, so 10-year-old kid had to go to the bathroom. Kid opened the door and took a leak behind the door of the car. Nobody could see what was going on. I mean, I'm sure we've all done that once or twice in our life, especially the guys out there. Women, I understand it's probably a little harder to get away with this. But yes, he was charged by the police for urinating. And to make matters worse, the kid was put in a police car. The kid was put in a police car, which is absolute horse crap. Okay? This is a picture of the kid being put in the police car. Because he took a leak. So, he's been sentenced by a juvenile court to 3 months of probation for taking a leak. The kid's Quantavious Asen. He's a third grader. And he's on probation for 3 months because he had to go to the bathroom. It wasn't like he was waving his tallywhacker all around or running up to cars like the police officers and smearing them on their face. Although it sounds like those cops probably would like it. He was taking a leak. That's all he did. And the police saw him do that. And oh my God, he had to go to the bathroom. Take care of all the crime that was out there. And yeah, Aaron says, when you gotta go, you gotta go. Yeah. Yeah. When nature calls, you accept the charge. Nature calls, you accept the charges. There's no getting around it. But he was taken into custody and then cited and released. Why did they have to arrest him? That's the part I want to know. Please use dark mode here. Oh, I don't know why this one's not showing up in dark mode, but ultimately he was charged in juvenile court, which they're calling it youth court here, of being a child and in need of supervision. Now, in Ohio, that would be considered a delinquency, and I assume that's similar here. And I will say this much, though. If a 10-year-old kid came in with a charge like this, the court would be looking to get rid of it. Like, the probation probably sit down with mom and say, like, hey, what's going on? Like, was the kid doing this to be in trouble, or were there other issues in the home? No, the kid had to take a leak. Oh, okay, cool. Yeah, well, we're going to dismiss this. This is stupid. The fact this went any further than it did was absolutely mind-boggling. But the prosecutors pursued the case, and a judge this week oversaw a sentence that included probation and requiring the kid to write a 2-page report about Kobe Bryant. Now, I don't know where the Kobe Bryant thing came from. I know people are thinking, oh, well, it was probably down south, so he's like, judge like, you're young, black fella, I understand. You probably like that Kobe Bryant basketball boy. You can do me a report on basketball and Kobe Bryant. I don't think it was that. Do I think it could have been something like, well, you know who was a really good black guy you can mirror yourself after is Kobe Bryant. Well, I don't think that. I wonder if he said, like, is there anybody you admire and respect out there? And the kid said, oh, I think Kobe Bryant was really cool. He did a lot of things, and he was very, he did a lot of good for the community. I mean, aside from all the stuff that happened when he was in Colorado, I'm just saying. I think that's probably where the judge said, oh, well, you like this guy? I want you to do a report about him and all the things he did in his life. I don't know, though, but still, this is nonsense. Kid didn't hurt anybody. He wasn't at home fighting his mom. He wasn't fighting other kids. Literally took a piss. That's the British say. He's just literally taking the piss. And, yeah, he is on probation, and this is actually very common for juvenile probation. You check in once a month. And, yeah, that doesn't sound like, and I understand at the end of the day, you're like, what's the big deal? Once a month for 3 months. He's bound by the terms of juvenile probation, which include curfews. You have to check in. You can't leave areas without permission. They're going to check up on him at school. That's a very common thing. Your juvenile probation officer will check in on you at school to make sure you're not being a little turd. and also make sure you're doing your schoolwork and everything. It is an infringement upon his liberty and his rights. And not only his, but his parents. So this idea of, oh, it's no big deal here. No, he shouldn't be doing any of this. This is absolute horseshit. Absolutely disgusting. J-Rock says, we don't sound like that. Well, you're not from Alabama. You're in Georgia. I said Alabama. Max Murrah. Hey, Max is saying the grape allegations against Kobe Bryant. Weird. Yeah. Well, that whole thing. And then Max says, Ruh-roh, you're in trouble. Yes. Oh. Guys say he should have done a report on Usher. Yeah. Porcelain Thunder says, it's not like he's R. Kelly taking a whiz on people. Yeah. Iconoclast says, this is Mississippi. I'm sorry, yes. It is Mississippi. So, that's... Is it Mississippi? Did I mess up here? Oh, yeah. Black child. Yes, he's just... I was born a poor black child in Mississippi, just peeing in parking lots. It's the new opening to The Jerk. Oh, you're talking about Kevin Hart and Tasha K? Yeah, I need to read that. I have not gotten to it. So, I do think it sucks. They're not going to appeal it, and he won't have a criminal record because it's a juvenile case. It's not really a criminal record, but it's probation. And I get it, because after a while it becomes a hassle. It becomes stuff you have to deal with. But they shouldn't have been browbeaten and dealing with this and having to deal with this problem. The system failed people by doing this. The system failed them. And I'm not going to blame them. They're going to harbor resentment against the system forever now. This family will. That kid's not going to trust the system. The system jerked him around just for taking a piss. I think it's bullshit. You got a 10-year-old kid now who thinks it's all a fucking joke and organized against him. It's hard not to believe that. Like somebody says, hey, man, the system's against you. It's all meant to oppress you. He's going to be like, I took a piss and they put me in jail. So, I totally understand why this is a problem. And this is right here. It's the principle of he shouldn't have to do anything. This is the point. He shouldn't have to do a damn thing. And this is absolutely disgusting. He had to do a thing at all. She's not sure if her son's skin color influenced his arrest. I mean, certainly, I'm not going to say it didn't. Because I think from what one or two of the officers ended up getting fired for what they did. And then one of them quit. I mean, but yeah, yeah, I don't think, I'm going to be a little, normally I say, yeah, it's not an issue. It's like, maybe this one was. Because the idea you're going to arrest this kid and throw him in the back of a police car, not just, oh, who are you, what's your name, and write him a citation and drive off. I mean, that's chicken shit too. But at least that's not as bad as, putting him in the back of a police car and taking him to the station. That is garbage. So. JC Adult says, do minors get a jury of their peers? Wink. No, they do not. The juveniles get a bench trial. That's all you're entitled to because you don't have peers. Now, there are cases in juvenile court sometimes. So, for example, if you get charged with contributing to the delinquency of a juvenile, sometimes you could be in a juvenile court and charged with that offense. And that would be one of the few times in a juvenile court where you're entitled, like in Ohio, for example, an adult can have a jury sit there. Now, typically adults are charged in, municipal courts for that stuff. Colette says the governor needs to commute the sentence. Oh, I think he needs to pardon the kid. If I was the governor, I hope he hears about this and looks at this and says, yeah, no, this ain't happening, kid, pardon. That's how this should happen. Governor should pardon this kid and let him go on with his life, because this is just crap. Scudex says maybe his mother was being intolerable and they amped up the drama to stick it to her. Then they're you know what? It doesn't matter. That means they're complete pieces of shit for doing that. Just absolute garbage. absolute garbage for doing that to a woman. You're hassling her and doing this to her kid? Yeah, the kid was taking a leak and you did all of this. A lot of people are going to get mad and question whether or not you guys are like a bunch of hacks screwing around with people. And now your answer is, oh, we're going to stick it to you now. Well, we're going to screw your kid over because we're being douchebags. Yeah, remember, the policemen like to claim they're professionals. She's a citizen addressing her grievances against the government. Remember, the police are the government. You know, and if they're that thin-skinned, they need to go start baking cookies for a living because this job ain't for them. You know, people like that, if that's how that broke down at all, are a bigger threat to democracy than Al-Qaeda ever will be. Durna says maybe they sat him in the car because the mother was not to be found. No, that wasn't the issue. That wasn't the issue. So. Oh. Jonathan Dugers for $1.99 says, thank you. Saying juvenile court is BS, by the way. It's worse than adults. Yeah, I mean, the funny part is juvenile court is basically best interest of the child. Doesn't matter what you're doing. As long as you can argue it's the best interest of the child, it's all that matters. Ultimately. So, yeah, Claude, oh, sorry, you meant pardon. Okay, yeah, we're on the same page there. I'm glad. Great minds think alike. Oh, look, Cynthia's trying to be relevant. I guess that sucks. You can go out and go have another dinner with a CEO somewhere. I know that's like your skill in life. Fernando says, for God's sakes, he was standing on top of the car peeing. He's not standing on top of the car peeing. Like, he did not climb on top of the car peeing. There's no question. There's no allegation that's ever been done. He was standing behind the car door. Oh. And yes, and I forgot to mention this part. Yes, the officer's decision violated our written policy and went against our prior training. So yes, they got trained a lot more. Got trained a lot more. Whole lot more training. You know, they violated that kid's rights and screwed with them. Well, they just need more training. They're just simple police folk. So, yeah, it was, yeah, just completely disgusting what they did to this kid. So. I was sitting there, you're wondering, that's all I've got? I mean, that's all you warrant. I'm not going to... That's all you get out of me. So, I guess have fun. Sorry I can't give you a disruptive guest triangle here. So, moving on, we have to somebody who definitely fucked around and found out in the Japanese tradition. Johnny Somali. If you guys remember, he was going around Japan, and I need to work with Max Mura and Meme Copium on this because there's a whole lot to it. Ran around Japan with speakers, a Bluetooth speaker, you know, and he'd be having the speaker playing like Hiroshima, Nagasaki, and then he had one time it was playing like anime sex sounds. And he'd play it everywhere while he's eating, while he's in the subway, just being a general scumbag per Japanese cultural customs. You're not allowed to do that stuff in Japan. Japan is a very private and personalized culture and society, and he was over there being obnoxious. And he was streaming it. Why? Well, because he wanted clicks. He wanted views. He knew what he was doing was wrong. He shouldn't have done it, but he thought it was so funny. It's so funny. And this is him, and like a dumbass, he did all this stuff and got arrested. He also has since been arrested for facing basically burglary charges because he snuck around a construction site in the middle of the night, which that hasn't been resolved yet. And he could go to prison for that. Maybe. And if you guys aren't aware, Japanese prisons are not nice. Now, is the Japanese prison probably better than the Ukrainian prison? Yes. But I would watch, I think there's on YouTube, if you look up Locked Up Abroad, there's a guy, an American guy who got caught smuggling like a pound of hash into Japan. He did like 2 years in a Japanese prison. Does not sound like fun. There's a lot of beatings. There's a lot of beatings. J-Man over on Rumble is saying, does Japan do corporal punishment like in Singapore where they might cane you? No. In Singapore, if you do drug smuggling, they kill you. So that's a bigger issue. No, Japan is not big on corporal punishment in that sense. What will happen is that the guards will beat the ever-living piss out of you. Especially if you don't understand Japanese, which you're going to have. It's kind of like the Foreign Legion style of learning. Like, you're going to learn, and if we have to beat it into you. So you better learn it quick. So he's facing criminal charges in Japan. The prosecutors demanded he pay a fine and not make any more videos, which I'm sure he's not going to do. So Ismail Ramzi Khalid, better known by Johnny Somali, was in court in Japan, and he was accused of, playing loud music in a restaurant, bothering the customers, and this is while he was on kick. And I love this. They accused him of obstructing the business of the restaurant, and there was no room for leniency. Yes. Super serious sounding. Super serious sounding. I mean, it sounds so bad. Sounds so bad. Mo folks saying, damn Automod. Yeah, that's on Twitch. I don't know what to do there. So what Johnny did, I love. Like we there's no room for leniency here. So he said, I am so sorry. I promise I will never make these videos again, which I'm sure is gonna totally not happen. And I will say he's actually been very treated very, very well because he has not been beaten up by the Japanese police, which, if you guys are not aware, most police outside of America will not hesitate to crack your teeth if you get out of line. Like in Germany, the Polizei, they ain't afraid to do it. And in Japan, the Japanese police will rattle your chiclets if you push them hard enough. Police brutality ain't necessarily a thing in a lot of countries. But he's been lucky so far. He has also been lucky that, groups of people who have hunted him down and have threatened him have not beaten him. But, that may change going forward. Anyway, the prosecutors want his punishment to be a 200,000 yen fine, which is $1,400. There's no room for leniency here for $1,400. Oh. So, yes, that is the best part. We have no room for this stuff. You'd expect this in a really poor country. We're going to charge you $1 million fine. Oh, no. Or you can pay me $15 American and it's all good. It's like, yes, we're going to fine you 200,000 of our units. It's only like $1,400. Like, oh, okay. I'm sure he's made that in donos in the meantime. So, Zero Smoke says $1,400 to him is a slap on the wrist. Yes. Very much so. Max Murrah says Johnny Somali also threatened a police officer to kill him or fuck him up. However, at the time, the cop no comprendo. Max, you're like trilingual. Japanese, English, and Spanish. Espanol. But they have it all in recorded footage. I wonder if that charge will come up. Ooh. I wonder how much time you face, for threatening a cop in Japan. Interesting. And he says, I'm embarrassed. I apologize to everyone I've caused trouble. Yeah, I'm sure. I will no longer broadcast videos. I want to return to my home country and continue my studies and be a role model. Okay, yeah, you're a role model. So yes, he broke into a construction site in August, and this is where he's facing the burglary charges. And then he ran around screaming Fukushima at workers. Like I said, this guy is an asshole. A straight sub 80 IQ guy. This is all just stupid. So yeah, you can't screw around on here. Cannot screw around in Japan, and that's the thing you guys need to, if you guys didn't know that, a lot of you probably already did. Don't go running around foreign countries screwing around because they will kick your ass. And it won't go well. It won't go well, and they're the U.S. government didn't seem to really get involved too much here. They're like, whatever. You don't want that. Where you're like, I want to see my ambassador. I want somebody from the embassy to see me. You know what happens? The embassy, the consular official comes in and says, hey, okay, what's your name? Ismail? Okay, you're a U.S. citizen, right? Yeah. Are they treating you okay? Are they beating you? No. Okay, cool. Well, have a good one. Bye. Give us a call if they start mistreating you. Like, that's it. There is no, like, oh, you're an American, you get to go home. That's not how that works. Bernie, I'm not going to do that one. That is very funny, though. I can't do that one. So, yes, Johnny's just, batting 1,000 out there. Good job, Johnny. So. And then the last thing, and I thought this was really interesting. This is from Twitter. And this is a case. Now, Winston & Strawn is a big-time law firm. They're big. They're huge. They were sued, and you're reading this right, for plagiarizing someone else's Rule 12 motion. Now, Rule 12 is under the Federal Rules of Civil Procedure. You're looking for, basically, motion to dismiss, and it's probably for motion to dismiss for, like a 12B6 motion, failure to state a claim upon which relief could be granted. And the Sunea Law Group registered one of their Rule 12 motions with the Copyright Office. So they sued a law firm for using their stuff, which I'm not joking when I say this. In law, you copy and use from other people. You don't reinvent, like, one of the big things here is you don't reinvent the wheel. Because you just don't. There is no reinventing of the wheel. Number one, why would you do that? You don't reinvent the wheel. Also, generally speaking, most issues have been litigated somewhere so far, so you're going to use, like, case law. And also, if there's parts that you can just, like, somebody's already done the analysis of, like, here's how the law works, the issue, the rule, the analysis, the rule and the analysis part, well, why wouldn't you copy it? That saves you time. That saves your client money. And if you've already done this before on a case, you're going to dig through your own stuff and republish it and just reuse motions. I mean, it's common. Like, when I have a case for, like, a criminal client and it's a discovery motion, I don't sit there and retype out the motion every time. Go to the file, click, he's got a file, and then there's another guy who's got a file. Go into the one that's already got a motion in it, copy the file, go into the new folder, open it up, plop it down, change the name, change the court date, change the court name, judge name, defendant name, file it. Why would I redo all of that again? Now, sure, will I change if I need to add stuff? Yeah. But why would I reinvent the wheel? There's no need to reinvent the wheel. So this whole thing is an actual joke because this group registered its motion as a copyright, which I think brings this law firm into a lot of trouble because I think there's an actual issue here because part of copyright is it's not derivative. It's got to be unique. Are they really going to claim that all of their work is unique and not derivative, that they haven't done it before or told or pulled from someone else? Number one. Number two, they were hired by a client to do work. And generally work for hire, especially in this type of situation where there's not an employee relationship, you're not entitled to a copyright. There's a further issue though. When you do work for your client, yeah, sure, I may own the work product of like putting it together, but that work I performed was for my client. I would argue they own that work. And I don't think you can take a proprietary I don't think you can take a property interest in your client like that. I mean, because it's their, like it's their case, that's theirs. It's not yours. You did it for them. They own, like, I would argue they own the property interest in that motion. I don't think they should be able to copyright it. I think that's complete, crap. But that becomes an issue of you're not allowed to go out and take advantage of your clients like that. You can't make, you're allowed to bill your clients and have them pay you, but to make money off your clients like this doesn't work. I think these guys have committed an ethical issue there. But in response to this, then I will say that there's a reason why Winston & Strawn is a big-time law firm. They don't hire people like me. Because I would have just written a response back saying, get bent, you toolboxes. I might have said, like, I want to cite the case of Lamal v. Bruh. But they didn't do that. They actually did a true response. And, they point out that your idea of getting full statutory damages, they didn't file the copyright till after everything had been filed. They hadn't done a lot of things right here, but I just don't see, I think it's hilarious that there's no willfulness here. And they put the document out in public. They haven't published it. There's an entire problem with this as far as copyright's concerned, but I still think there's a property issue there, and I'll be curious to see if this law firm withdraws it, because I think this is highly frivolous and should be sanctioned. I just thought it was funny. This is very true, and I'll give this attorney credit because he says, respectfully, we don't believe a court will welcome your request to use copyright law to interfere with his representation of a client, especially where the lawyer could have accomplished the same litigation strategy by joining the motion. And that's the other issue here, too. Winston & Strawn and the other law group are like co-defendants, representing co-defendants. The difference between allegedly copying a motion and joining is one of form over substance, which will only further reduce any possibility of statutory damages. In summary, even if one were to assume a copyright infringement, the monetary value is de minimis, which means that they get like $1. Nonetheless, as you requested, I encourage you to contact me at your earliest convenience. This is very nice. I would have been... Oh, God. This would have been bad. I think these guys are smart, though, but they should have given them a Rule 11 warning and forcing them to withdraw it. I am amazed that these guys dare thought to copyright their motion like that. That is, yeah. It's just absolutely nonsense. J-Rock, you're saying I'm correct. Are you saying I'm correct about the client owns it, so it's their property interest the law firm can't take? Because if I was correct, I thank you. JC Adults, is this the one where they use the AI which got the case wrong? No, that was up in New York. And remember, the funny thing was they didn't get in trouble for the case law issues. They really got in trouble for lying to the court about a bunch of other nonsense. So that was what really screwed those guys at the end of the day. Now, the AI stuff was a problem, but that was their problem. Some crawling on my leg, just like a spider. Ugh. trying not to look, but I felt like something was crawling on my leg. Amateur Iconoclast says wheels are overrated. I guess. Two Scoop says the copyright is for creative works, not useful articles. Yeah. I think just because you can copyright it doesn't mean it's going to stay. You can get a patent for something, and a court and a patent examiner may say, this isn't a novel invention, this is actually something you shouldn't have, and they could say, patent's gone. And I think this really went to court, and a court could say, nope, there's no copyright here, get out. Which they probably should. Alpha Fox says their motion had no citations. See, that's the thing. I don't think that's actually... Their motion would have had citations, and there's nothing wrong with having the citations. But they're arguing the way we did it, we're copywriting that specific pattern of motion, those specific words. So. Kimonoi says you can't copyright scientific theories, so you can't copyright law theories. Yeah, but that's the neat thing. When you're dealing with lawyers, they'll make excuses to get around that. So, yeah. Fernando says, was it that original? I doubt it. Mystery Sniper says, how can there be a copyright on a legal motion or anything from a court? It shouldn't exist like that, but apparently an attorney got away with this once. It's just garbage. J-Rock says, was it on Pacer? Yes, it was on Pacer. They only filed the copyright notice after they found out the other firm basically changed out the bottom and said, instead of the Suania Law Group, Winston and Strawn, Sean Martin, Winston and Strawn at the bottom. It's almost like if you wrote it and then I just erased your name and the phone number and put down my name and phone number. It's like, yeah, we're same, literally the exact same because they're co-defendants. That's the funny part about it. Bernie says, imagine copywriting a law filing thinking no one would ever make a legal filing. Sounds vaguely similar. Yeah. Egalitarian says, is plagiarism illegal? No, it's not. And the funny thing is, when you're in law school, they sit there and J-Rock and anybody else out there, they make it sound like if you plagiarize, oh my God, they're going to kill you. Like, they're going to take your law license, they're going to suspend it, and then they're going to, like, start skinning you alive and then start ripping your teeth out with pliers while you're conscious and awake. And God forbid if you cite a case and you mess up the number and, oh my God, God help you. That's literally how the legal writing classes are taught. Once you get to practicing, hey, I already did this motion, use this one. Or I've been, in my interactions and doing contracts and different things over the years, parties really, oh yeah, here's our documents, and I've created documents and send them back and forth. Or, parties like, oh yeah, here's the document we're using. And they email it to me. It's like, oh, that's interesting. You know what? Click save, and I keep it in a file of documents sent from other parties. Because sometimes they have things I think, oh, I'm going to pull from this. You know what? I like how they worded that. I'm going to word it like that. And I'll do some, hey, does this part work right? And I'll do some research later saying, oh, you know what? That works. I'll keep that in mind if I have to do a document from their position. Like if I'm in their position where I'm dealing with another party. It's, business forms, all that stuff. You build off of other people. You build off of other things you see. And in the legal world, it's no different. That's entirely how it happens. J-Rock says the plagiarism in that too. Yeah. Dell says the schizo phantom spider appears. Oh, that is... Laugh all you want. Spiders are scary. Pitchlock says law really science. Hey, it says doctor on my degree, so I'd argue it is. Alpha Fox says hashtag motion banks. Yes. J-Rock says, I plagiarize like Godzilla treats Tokyo. Yeah, that's entirely true. Entirely true. So. Ag says, Sean hasn't met a peer reviewer before. They're see you next Tuesdays. Hey, I understand that in the academic world, but I'm just saying in like the real world, man. I remember when I was in law school and I was an intern. I was interning in the prosecutor's office in Toledo, and I remember dealing with a motion. They like, yeah, hey, read this and do some research on it. I'm like, okay, so I'm reading it, and this is like an old time lawyer. He's a boomer lawyer. And his motions will look like they were typed up on an electric typewriter. You could tell he literally copied and pasted like the legit, like the term copy and paste comes from when you would sit there with like a pair of scissors, like, and you cut out parts of a motion and you glue them to a piece of paper, like you literally copied and pasted stuff. And I read it, and it's, you're reading about defendant Bob, and then it says, well, the defendant, she did this, and then it turns out it's like defendant Susie. You're like, what? The same fact pattern and the same facts had arisen. This guy had been practicing forever, so after a while, cases do kind of have similar facts at times. And I go to the assistant prosecutor gave it to me, and I'm like, hey, he like copied and pasted. Is he allowed to? I'm like, is he allowed to do that? Isn't that like plagiarism? And he just looked at me and he said, oh, you're in legal writing now, aren't you? He said, it doesn't matter here. I said, is he going to get in trouble? Like, are you going to get mad at him? And he's like, no. Why would I? He's like, that's not a problem. What are you worried about? And that's when I said, so it doesn't matter? He's like, no. I said, the judge is going to see this. Do you think the judge cares? Like, no, judge does not care at all. And yeah, nobody gave a shit. And that was really great to have going on in the middle of my legal writing class with like, oh my God, they're going to fucking kill you. They'll rip your teeth out. And I'm just sitting there like, no, I literally just saw this happen in the real world. Nothing happens at all. And oops, if you mess up a citation, oh, counsel, it's not right. Oh, sorry, Your Honor. Yeah, here, fix it. Sorry, that's actually the correct citation. Oh, okay, cool. That's the real world. Sean was lucky I didn't see Aussie stream this morning where the lady had a Nessus bite. Oh, God, no. Oof. No. J-Rock, yes. If someone as a lawyer, someone argued and won your issue, copy them. Yes. Now, that doesn't mean you take from that. What did they do right? Did they cite the right laws? What laws did they cite? Did they cite things different from me? When I do appeals, if I do good on the appeal and the court, but I've also seen where the court adds or cites different case law, guess what I do? I copy it. If I lose on an issue and the court overrules me, guess what? I use the reasoning they use for the future because it's their reasoning. And the same thing with the opposing party. If they got something right, I look at their arguments. Yeah, you have to. You have to. You can't just ignore them. Or you can't be like, oh, I can't use them anymore. No, that would be horrible for your clients and horrible for the practice of law. So, Bernie says, so basically you're saying they're treating this like the law section of Reddit. Yes. Aaron says, I'll thank you to keep the real world out of my classroom, Mr. Martin. Yeah, I actually asked my professor, I'm like, I just went through all this and like nothing happened. What's going on here? And she's, but I mean, you have to follow the rules of law school. So it wasn't like you could go around and plagiarize shit. So, and copy and paste. Alpha Fox is saying, my most liberating moment in law school is when I realized that saying, I don't know, shuts down the whole Socratic method nonsense. Oh, and outline supplements made for textbooks. Yes. Yes, that does destroy the Socratic method, although I hated Socratic method. It's not anything impressive. They just keep asking you questions, and it's not this brilliant thing that it's all cracked up to be. So this is just. I hope this law firm gets spanked hard for it. All right, guys, that is it. We've caught. Did we get everything on here? Where, let me see here. Where'd my list go? Hold on here. Come on, come on. What do we got? What was on the list tonight? Jodi Hildebrant, copywriting emotion. Yeah. Yep. I'm going to look up that whole thing with the truck that was mentioned earlier. That sounds really funny and interesting. I mean, doesn't sound funny. The guy got drug out of a truck and smacked onto the ground, but yeah, I have no idea. I want to look into that one. That sounds interesting. All right, guys. So that is it for us. We are all caught up. We are all done. I did want to say we've got a 2024 is going to be interesting. We've got Sarah Boone. We've got Brian Koberger. We've got all kinds of things. We've got what's going on in the Murdoch case. There's actually going to be a pretty big year of trials, things that are going on. We've got everything involving Trump. We've got the election. All I can say is it's going to be a fun time. It's going to be great. And then the other issue is, it's a new year. And I think it's going to be interesting. It's going to be interesting. And if you guys had a bad year this year, things didn't go your way, it's a new year. All you can do is put a good foot forward and make it better than this year. And, I'm going to make this year better, this year coming up better than this past year. This is the last time we'll talk this year, too. Next time I see you guys on a Thursday show, it will be in a new year. Now, I might do something Thursday night, or I'm sorry, Thursday, I'm doing that right now. God. Might do something Friday night, might do something Saturday night, probably not doing anything Sunday night. So, but if I don't see you guys in the meantime, Happy New Year. Take care of yourselves, be safe out there, and I'll see you guys next year. We will be doing locals, and we're going to be over at locals right after this, over at potentiallycriminal.locals.com, hanging out, having fun. And it looks like, before I get too far, there was a super chat here. J-Rock for $4.99 is saying, Sean, Cecil is hosting the Jack Show. Get on there. I don't know if Cecil's ever gonna, and that's on him. That's on him to invite me on. I don't know. Jack Show's not bad. I enjoy listening to it from time to time. Especially it helps now I know what the Jack, like the abbreviations JACK mean. Hadn't really put it together till one of you guys pointed it out for me. So, but thank you for the super chat. I appreciate it. Yes, Joe and Pisco are on right now. We might stream sync them for a little bit, see what they're going into. And, yeah, we're going to go over to locals, guys. So, for the last time this year, just because you did it doesn't mean you're guilty. Good night, everybody. Happy New Year. Take care of yourselves. And I'll see you guys next week.